subscribe now and press the bell icon. Never miss an update.
Namaskar.
Shanta Madam.
Thank you very much for a great introduction. Thank you very much for giving me an opportunity to be with such distinguished panelists also. It's a great opportunity for me. And now, if I have to talk about the development and the reforms in judiciary which has been made by our Honorable Prime Minister, this 70 years, whatever has to be done in 70 years has been covered in 7 years, and which has to be covered by me in not in 7 minutes, by 3.5 minutes. So, which is a real tough task for me, primarily because our Prime Minister, under his leadership, it appears that he has given us such a clear instructions to the policymakers that wherever the law is lacking, wherever there is no law at all, there is a vacuum, all those areas have been completely getting covered. For example, let us take RERA, Real Estate Regulation and Development Act. There was no law at all governing that area. Different acts like Delhi Apartments Act and different the Transfer of Property Acts. So the movable property, wherein it was about thousands of crores of industry it is, and we did not have an organized, systematic real estate law which will regulate both the customer who is going and paying the money to all these builders and everybody, to real estate people, and they don't even know what is going to be the layout. First day, what is the layout which is shown, and when they get the property at the end of the day, the property which they get, absolutely there's no connection between the layout and what will they get. There is no time limit. They would not even know whether they are going to get it at that appropriate time, and whether if they don't get it, whether they will be compensated. In the same way, there is no registering pattern. Now the registration is mandatory. 70% of the money which is being collected by the real estate people, it has to be put in an escrow account, so that at least as a consumer, all of us are consumer at the end of the day. When we give the money, we know at least, okay, that money is being spent only for that project. So likewise, there are hundreds of regulation. It will all bring in a discipline in the whole industry. This is one of the RERA Act. Coming to the corporates, Insolvency and Bankruptcy Act. Previously, we were all rushing to the civil courts by filing a civil suit, recovery suit, or a 138 under, if at all, if there is any default in payment, or under Negotiable Instruments Act. Ultimately, we used to go to a winding up of a company, if at all, if the erosion of the capital of that company. And there was a legal hurdle, because if for a recovery, you cannot go and file a winding up petitions, because we remember the days wherein we only used to, as a last remedy, we used to tell our clients, please file a winding up. And there we used to face a situation that it is not a recovery tool. So because of that, the people who have supplied money, supplied products and waiting for their money, the debtors and the creditors, there was a big gap between them for the recovery of the money, which was disturbing the flow of capital and the finance for every corporate. So this Insolvency and Bankruptcy Code and the NCLT, NCALT, and 330 days, the insolvency professionals have to complete the process. And once you issue a notice, within 15 days, a reply has to be received. You cannot create a new dispute which was not existence earlier. You create it only for the sake of you don't want to pay it up. So all those things got completely covered, and the corporates became very happy, and it has been a very, very effective act, the Insolvency and Bankruptcy Code, after repealing the SICA Act. Likewise, if we see the GST introduction does not even need any introduction, because the kind of a uniformity, the kind of a free-flowing payment of taxes, and with the interconnection between the central and the state, so that is a path-breaking law which has been brought in. Coming to the personal law, the Muslim law, protection of rights, that protection, that which is triple talaq, because an woman of this country and being thrown away by 1 minute talaq, and which has been there for so many years. Now it has been considered that yes, that woman also has a right to say accept it or don't accept it. At least she has a legal remedy to that. So this act brings in that, gives in that right to that women, Indian woman. She is also part of an Indian woman. So that right has been given under the personal law. Then coming to the Jammu and Kashmir Organization, the President Ordinance of 1954, which it has a specific word of temporary. That temporary has come as ended in 2019 by the abrogation of 370 and 35A, which was an offshoot of the 370. Can this word of temporary, can it go on for this long? Is it necessary that our leader, like our prime minister, has to think that, oh, the temporary period has come to an end? President's ordinance of 1954 has to come to an end. Does it take so long to think that yes, it requires a change now? Then coming to the transgender, because that is a sociological change. The Transgender Protection Right Act, which has been brought in, that is because the society requires it. So that also has been brought in. Then in the election manifesto, coming to the black money, then there is a Black Money Undisclosed Tax Act, which has been brought in because it was stated so in election manifesto. And he proves and says and shows that, yes, I stand by whatever commitment I give. The next is Fugitive Economic Offenders Act. Again, we never had an act like this. These are few of the examples, Mr. Bharat, which shows that there was a gap between what the requirement of law and what was there in law. So although with few of these acts, there are so many acts, because 140 and for 1040 14 and 1400 acts were repealed, starting from 1850 1848 enactments, and 1400 acts were repealed. So when all those obsolete and inapplicable acts were repealed, and all these, there was at least a process to think that yes, this requires all these, there is a gap, and all these laws have to be brought in. And at the same time, let me just cover it in 1 minute as to what are the new amendments which were brought into the existing laws. A great amendment is on Arbitration Act. Arbitration Act of there was 1930 Act and then 1996 Act. After 1996 Act, in 2015 and 2019, the amendments were made. Why they were made? Primarily because to repose a trust on the international arena. Because there was so much of trade which has started taking place globally between India and other countries. So, and in every transaction, in every agreement, there is an arbitration clause. And the arbitration clause, unless it is time bound and unless there is a specific timeline which is given, and at the same time fee structure which is given, and at the same time section 34, which is an objection for award which is being filed, and there also it gets restricted, and award becomes a finality earlier, so that the internationally the other corporates who deal with Indian companies, they get a kind of a confidence to deal with India and Indian corporates. So that was to make it institutional, also to make arbitration institutional. So this was an extremely important requirement of global requirement. So because of which Arbitration Act was repeatedly amended in 15 also and 2019 also, about which Justice Indu Malhotra, Justice Nariman, they are all so happy, and they have given so many multiple presentation on different forums, saying that these are the kinds of amendment which is very necessary to repose, to show to the world that we are at par with, and to make it, and also to make it as India as a hub of arbitration. Then coming to the within domestic motor vehicle act, because the children have started taking out the cars and bike at the age of 15 and 16. The rash driving has to be curtailed, and the drunken driving, because the society requires all that. So the fine amount was multiple times it got increased, so that it acts as a deterrent effect. And last, the latest one is Consumer Protection Act on 20th of July, which was enacted, a new act which brings in for e-commerce. There was for e-commerce, we did not have any law which will restrict, which will show a path as to that, what will be the liability, what will be the responsibility. So the product liability, which is extremely important, and wrong advertisements. So all that, to cover all that, the CP completely, the Consumer Protection Act, the act was amended and was repealed, and the new act has been brought. So now coming to my conclusion part of that, what is going to be done? In every stage, what happens is that we have never been knowing that what is going to be done. Let it be for policymakers, let it be for citizens, or let it be for lawyers like us. So because nowadays we don't even keep down the book. the number of amendments on the new act which is coming in. So we are not even able to keep down our books. So all the time we are on the toes. So now at least, so we also, at the same time, we also know now as to what is going to happen, for which is extremely important and which is very extremely impressive also to note. Now there is Vision New India 2020, under which there is a litigation assessment and audit which is taking place. So what is happening is, in that audit assessment, the policymakers have started studying from the day of dispute when it arises till it gets implemented, whether it is a suit, whether it's a decree, whether it's an arbitration award, whatever it is, till it gets implemented. What are the stages? And by studying that, they want to understand that why is it there is so many disputes, so that once they collect those, they collect all those data and assess it, they will come to know that as to why, because there is no meaning in talking that there are 3 crores of litigation which is pending, 3 crores of litigation pending. By such big shouts, nothing is going to happen unless we really take productive steps towards it. So this assessment is going to make a big difference to the government to decide, to understand as to where it requires much more trust and why there is so much of a litigation. Likewise, national litigation policy is there to reduce the litigation. In our country, the major litigant is government, and it is a known fact on the basis of the data. So now the government is taking steps and want to formulate guidelines as to that why the government is all the time getting into litigation, and if that can be done, how to restrict also the litigation of the government. Once the government litigation is reduced, genuine litigations nobody is talking about to reduce, but the number of government the guidelines is formed and the government litigation gets reduced, that will considerably bring down the burden on the courts also. Likewise, there was an act which was passed to increase the number of judges in the Honorable Supreme Court from 31 to 34, because that was again a requirement of the present situation. So likewise, these are the in few minutes which I can cover, the reforms which have been repealing of the old act, bringing in new act wherever it was necessary, bringing in the amendments wherever which it all required, and then showing the path as to where we have to achieve. So this is how it has been devised, and there cannot be, in my exclusive opinion, there cannot be any other better way of bringing in a reform in any country, in such a huge, big country like ours, wherein the roadmap is laid down. Everybody knows this is how it should be done. Please move towards it. And when we move towards that, as everybody, judiciary, citizens, corporates, lawyers, advisors, everybody move towards that. And there is no way that we cannot achieve the real point or mission where we want to achieve. So for which I really thank our national leader and a person, because of his hard work, because of his, I don't think he takes rest at all. So because of his vision, all these reforms have come. So I wish that God gives him more and more strength, and India brings in more and more reforms. Thank you very much for giving me opportunity.
Subscribe now and press the bell icon. Never miss an update.